Number 13. And my conscience my mind's going, hey, you should be out there shoveling some snow. We got some more snow here. And so as long as I can keep that at bay, I'll just keep on going with it. If I keep on ignoring that, get out there and do it. Oh, that's right. It's opposite mirror thing here. As long as I keep on ignoring that inner voice, I can keep on going. Okay, so what are we? 13. Parliament. See how syllogism, we just God, going to monarchy, we discuss some of the various aspects of the Christianity and Judaism and those kind of things. And now we're moving succinctly from law, monarchy, and now we're moving to parliament. Parliament means essentially discussion, discourse, from the French word parler, or meaning to talk. Parliament's origins before AD 1066 and the Norman Conquest was known as Witenagemot. I'm going to bastardize that. It's the first time I've actually had to pronounce it out loud. Witenagemot. Witenagemot? Or Witan for short. I like that word. After 1066, the king's tenants-in-chief formed a council, the system making laws and hear disputes among the lords called the Curia Regis, which also consisted of a group of ecclesiastics. Parliament, the higher courts of law, the Privy Council, and the Cabinet all descend from the original Curia Regis. Lord Spiritual, interest in the use of land held in corporate perpetuity, immediately subject to the common law. Look at the word immediately, not immediately, but immediately. And Lords Temporal, interest in land first held immediately under the monarchy via service and the rules of inheritance. And later the Lords Common, interest in property held in equity subject to a trust. Do I know that? Absolutely. Did I read it? I never read it that way. That is right there at that point. That's not it's absolute. Did I read it anywhere in law? I just came to that conclusion by how I thought that they would be segregated within Parliament, originating in England. Okay, so it doesn't need to be absolute. It doesn't really matter. Like I said, you don't deal with government. You don't have to. So that the monarchy is supposed to do that for you. Okay? Parliamentary privilege was established at the promulgation of the Bill of Rights, 1688, and we already went to that. We won't need to, get into it. Now, we discussed at the very beginning that English law is predominantly just in the right of another. So you're holding for the right of another. Okay. When we get into government is master and slave. Okay. It's actually voluntary servitude. And we also use the word slave because slave is just debt. Involuntary slave is that you're confined to a monetary obligation, where involuntary servitude is you're confined because somebody's forcing their will against you to do something. Okay. Rights granted from the monarchy to administrate over defined territory as proprietary interest. And that's what all these territories are. It's a territorial jurisdiction. Unlike your dominion right, it's an individual inner jurisdiction. Government has a right over a proprietary interest over a territory. So it has a different subject matter. That is different, as you see here, than the common law, which we've already went top down, how we got to this point, that the territory interest is going to have a whole new set of rules. And as soon as you deal with a set of rules, there's the courts in order to adjudicate those matters subject to those territorial rules. Okay? Government has no rights to either the common law interest held in the monarchy or the dominion right. It has no interest because it can never have that interest. Okay? And plus, it can never be a tenant for life because it's not living. It is a fiction of law. And that fictional law has been given and granted the right to use the land for the benefit of those who want to use it. And there's your privileges, use to land. Okay, it's proprietary interests. Those proprietary interests, I'm sure, are held with the Lord's temporal. Okay, the lords of yesteryear just, the tenure system really has not ever dissolved. It's just that the feudal system the word feudal is gone, and we've given rights to everyone equally to possess land as assumed owners. You can never be allodium owners to land. It's impossible in English law. Get over it. You can't do it. Whether you have patent, the patent again comes in under what? The power of that patent who gave that right. Therefore, that's another hierarchical system of landholding. Who has that right to create that patent in order to give you that subsequent interest? And that interest in that patent, what is it to? I'll guarantee it's on trust. There's patents upon patents. So let's just get to that succinct realization that its subject matter creates jurisdiction, and you're only going to be faced with what you're able to speak to and what you're arguing about. And you're arguing about property and the government? Okay, well, you're going to get what you're going to get. And we're going to go into further why you don't want to do that. Okay, rights granted from the monarchy to administrate over defined territory. That's what government does. They're just administrators. It's like a property management firm. Okay, and what they are to do is do the accounting of all the waste that's created on land. And waste is whether you're putting up a building or taking down a building. It doesn't matter. Okay, and it creates the rules in order for that to happen. And the more waste it creates, the more power it gets, because the more legislation it creates in order to affect that power over the waste and those people that are using it based on their actions and interest in it. They have no power over the people that have a right in the common law. They only have the power you give them under the interest that you're holding. They can't do anything different. They're not doing anything to you. I'd say, yes, they're evil. There's a lot of evil. I'm not advocating that they're not doing that. I'm saying that if you're not in that agreement, and other people are not in agreement, and let's say majority are not in that agreement, then they have no power to do what they're doing in the first place. You have the power, Dorothy. Okay, stop using that straw man and tin man and all those kind of things, and fighting against a straw man is just as nonsensical as fighting against the smell of a unicorn fart. It's just nonsensical. Stop fighting the fiction. Developed from original letters patent granted to corporations. Governments have a secondary interest to land to an equitable use. We've realized how we got to equitable use. They are regulated by their constitutions, and these constitutions only apply to government and its franchises. They make laws according to the management of waste, only which is the use of resources coming from the land. Waste is regulated whether one constructs or deconstructs. All right. Going into court next.